so sure we forget that part. We're always talking about the legal process, and when you see stakeholders, when you see non-governmental organisations, they are always talking about the legal process. They're talking about whether there can be sanctions of a criminal nature, whether there can be civil accountability. So, for example, children born of this behaviour of sexual exploitation may receive maintenance, may receive paternity inputs from their fathers, for example. Certainly it's important. The legal process, my belief is you get a perpetrator to be accountable in a legal way. That is a very strong message to others. The law is about more than accountability. It's about putting a line in the sand, indicating exactly what will not be tolerated. But the legal process is hard, and the legal process is hard not only in international context, but at the national context. I mean, when we talk about sexual crimes, when we talk about paternity claims, even in the best, and I can't even think of the best national jurisdiction, they're not easy. With a criminal claim, you have the proof beyond all reasonable doubt on the balance of probabilities. With a civil claim, in our system, we have administrative sanctions. The UN has administrative sanctions. The level of proof is probably a little around the same as a civil claim, but there are other things that can be done. It's important for the victims. It's important for the UN. It's important to create a strong message that there is zero tolerance for this behaviour. But at the same time, there are other ways of showing accountability: apologies, an indication of real understanding, and a real desire to elevate the rights of victims and ensure that those rights are realised.
And finally,